Law. Buckle up for a fast-paced exploration of the latest updates shaping the legal landscape of India. The panel will be moderated by Dr. Chandra Damle, an in-house IP consul at GIPC, a leading gaming and entertainment company based in India. Dr. Chandra is currently leading the IP practice and managing their global IP portfolio in gaming, esports, and music. With over 15 years in the field of IPR, she is adapting patents, copyrights, trademarks, and industrial design laws, and also serves as a co-chair for the Indian IP Alliance's Education Committee. Okay. The speaker joining Mrs. Damle in this session is Mr. Abhay Pandey, a senior partner and leads the litigation and enforcement team at LexOrbis. He focuses on IP litigations, criminal enforcement, contested proceedings. He also advises clients on brand protection, strategies for social media, the internet, and advertisement. We will wait a few minutes.
So good afternoon. Now since the earlier speaker was mentioning about the IP updates on Turkish law, so I've noted a few points so that we can have a comparative view about the Indian law and Turkish law. So a few points which I noted was about injunctions. Now they mentioned about injunctions. So in India, basically the scenarios, we have few criteria like in India there should be a prima facie case and the loss should be irreparable. So the scenario is quite similar to the Turkish law, and also with regard to enforcement system mechanism. In India we have Indian patent offices under which there are trademark, patent, copyrights and designs. Judiciary plays very important role in India because many a times a law which is not in the books is interpreted by the judiciary and even they set the law. So we call it law by precedents. And of course police, that is machinery, plays very important role when it comes to counterfeiting because with their help we can conduct various raids. So setting the context, what I thought that since both of us, we have not made any presentations, so we'll keep it interactive. We will be happy if anyone from the audience wants to ask us question or add any points. So what we are like, we are keeping it like a discussion kind of point, like where I start and like my co-speaker can elaborate on the further points. So would you like to say something about the IP enforcement and injunctions which the speaker mentioned?
Yeah, Siddha, before that, probably I would like to give some historical background and put the Indian IP law and system in context. For India, we had IP laws right from the late 19th century, and most of the IP laws were there introduced by the British, which was primarily objective or catering to the interest, or which was the colonial interest at that point of time. Then in 1947, India became an independent country, and as an independent country, we adopted new IP laws, which were more designed and created to help the IP ecosystem in a developing country scenario. So the first post-independent trademark law was introduced in 1958, copyright law was introduced in 1956, patent law was introduced effectively in 1970, and these three major laws had some unique provisions which were more designed to help the developing the Indian businesses, like patents law, which was enacted in 1970, was not providing patent protection to all inventions effectively, and some of the inventions were being kept out, like the chemical and agrochemical and pharmaceutical patents were not, the product patents were not allowed. So that 1970 Patent Act and 58 Trademark Act continued till 1991, when India opened the economy and became a global participant to the global economic scenario. During that 1991 when we opened our economic system, we also integrated our IP laws with the international standard. So we signed in 1995, we signed the TRIPS agreement. TRIPS agreement provided for the, like the quiz was asking about the WTO, because we became member of WTO, so we had no other choice than to enter into TRIPS agreement. And then that TRIPS agreement was providing base minimum standards to be adopted in national laws, which are more designed towards globalization of economies, including the Indian economy. So, but being a developing country, we have been given time of 10 years window. That is why, so we signed the TRIPS in 1995 and were given time till 2005 to adopt the TRIPS compliant laws. And so therefore, Patents Act of 1970 underwent significant amendment and change, which and introduced patentable introduced new patentable subject matter, including pharmaceutical and agrochemical patents. Then also the standards relating to both enforcement as well as the protection, procurement of protection and the patent law underwent significant change in 2005. Similarly, trademarks law was changed in 1999 and a new act was introduced which became effective in 2003. Copyright law itself did not was not repealed, but the 1956 Act underwent significant change in 2012 to incorporate the WIPO internet treaties that WPPT and other performance rights treaty. So effectively, post 2005, we had new set of Indian laws which were TRIPS compliant and also followed the international standards of both on procurement and as well as in enforcement and protection. I'll say now, coming back to the recent years, that was the historical thing. Now coming back to the recent years, the significant change happened in terms of administrative and statutory change happened very recently. I'll say the milestone time will be on the administrative side was the India adopting a first national IP policy in 2016. That was the first national IP policy introduced to the country. The IP policy was aimed primarily to act on all the fronts of creating IP, making things easy for procurement and establishing a very robust IP enforcement system in India. So these three major objectives, when the policy was adopted, was being implemented, and we saw significant change happening both from the in terms of creation of IP until around 2021. Indian Patent Office was receiving almost 65 to 70% of the patent applications which were being filed by the international players, like the global companies coming from Europe, from US, from China and Japan, and they were predominating the Indian patent filings as such. But in last 2-3 years, there have been a significant change, and the implementation of national IP policy is now being resulted in a manner where we have almost 50% of the patent applications coming from the domestic companies and 50% of the applications coming from international players. So similarly, the numbers of patent filing has significantly improved. I'll say has been doubled in last 5 years. We had almost like 50,000 average patent applications filed till around 2017, whereas the last year it is just 100,000. So we have 100,000 patent applications filed every year. Out of that, 50,000 applications are being filed by the domestic companies and the domestic institutions, whereas the 50,000 applications are coming from the international players. Now, with this increase, they also needed the filing, so that there have been significant improvement on the creation of IP. But to handle the increasing volume of patent application, there was required to make some administrative changes, and that was one of the objectives of the national policy to ensure that the Indian patent system, particularly administrative system, where the grants takes place, are being made much more effective. The scenario was at around 2016 when this policy was adopted. We had only about 125 patent examiners and controllers. The number was almost made 6 times in a span of in about 6 years. We now have almost like 600 patent examiners and controllers. If I think put together will be so about 800. And since the increase of the numbers of filing is growing tremendously, the government is also planning to now bring in another set of 500 new examiners. So making almost like 1100 examiners, which we expect to have to come within maybe mid of this, somewhere around near to the end of this year. And if that happens, then the objective would be that one patent examiner handles only 100 applications a year. Like we have 100,000 filing and 1100 examiners, so on average, one examiner will be handling not more than 100 patent application in a year, which will, of course, is likely to bring in more quality of examination as well. So one is the quality and other is the speed of examination. So around that time when the new policy was adopted in 2016, the examination period for a patent application was like 5 to 6 years. So a patent applicant, if they used to file request for examination, they were getting the first office action or the first examination report in about the span of 5 to 6 years, and the grant was taking place in almost like patent grants in about 10 years time. That has been significantly reduced and improved. Today, average examination period of a patent application is about 9 to 12 months. In some art units, I would say particularly biotechnology and chemistry, it is less than 9 months. We receive the first office action in 6 months time. So there has been significant improvement in terms of both quality as well as the speed of examination of patent applications. Similarly, we have seen a tremendous change in trademark administration system. We in India, we see almost like 500,000 trademark application filed a year. We still say that we are third biggest filer. So I'm not sure how to say is second biggest. But there also the biggest issue was the speed of examination, and it used to take almost like say about 10 years to get a trademark registered till around 2016 when the new policy was adopted. But the resolve of the government and in implementing the policy resulted in using more technologies. So all the trademark and patent and design database was digitized by then, and we have seen in recent years the examination period for trademark application is reduced from 5 to 6 years to 5 weeks, and in some cases we have also received examination reports within 10 days. And the grant of registration has been reduced from 7 to 8 years to now it has been reduced to just about 8 months. So I'll say a lot of administrative changes, a lot of the government's implementation on increasing the strength, capacity of the IP officers in India, making rules and procedures much more user-friendly, simple. I will talk about some simple, some recent changes which have been made in the patent rules to address the pain points of the international filers, and how we expect that these new amended rules is going to bring in more filing of patents by the international players. We expect so. So I'll address those. I've been talking a lot, so probably now it's that report.
Yeah. So basically, since you were mentioning about the functioning of patent offices, so when I'm referring IPO, that is Indian Patent Offices, it includes all our offices, that is patent, trademark and copyrights. So now IPO offices in India are taking a lot of proactive measures. Okay, so there was a huge backlog, as you mentioned, because there's a huge filing, but the infrastructure and the manpower was not adequate. So now, as you told, that there are a lot of employees have been taken to address those backlogs, and earlier the filings were totally manual. So digitization of all those old records was humongous task for Indian Patent and all the offices. So now the digitization is taking place, now all the filings are online, but still there is, I guess, because of this backlog, there is still prosecution time is not minimized, which should be minimized soon. Apart from just filing process, IP offices in India are taking a lot of sensitization and awareness program, because I believe it is not just filing of IP or any intellectual property, but it is also respecting and creating awareness among the citizens. So that is also a lot of initiatives are taken, like Make in India, and many innovation and initiatives and programs are run by the government. Subsidiaries are given to the individuals who are under the Startup India program. So even the subsidiaries in India are given to the individual inventors. Now we spoke a lot about the histories and about the patent law. I would like to touch upon some of the judiciary and some of the important judgments that are given by the Indian courts. The first point I would like to mention here before that, now recently after 2015 amendment, India had started commercial courts. Now I guess I've seen just now that Turkey already has specialized IP courts. So we don't have specialized IP courts as such, but we do have a commercial courts. And there is no expert or a panel that sits there, but the judges decide the case. If required, the subject matter is appointed externally, which is with only the request. There is no expert associated with the courts, but depending upon the case and request of the parties, subject matter is appointed case-to-case basis, provided they follow the certain rules and procedures. The interesting case that I would like to share, a recent case, is a Lava mobile case. This is related to antenna invention. Now the huge damages were awarded in this case, about 70 crores I guess.
That twin beam antenna is the case is the CCI. Yes. That is 217 crores, which comes to around 30 million. 30 million.
So this is first time a landmark judgment given by the Indian judiciary, where the huge damages and awarded in the patent cases, which is actually a welcoming decision, because now people are taking patent infringement as a serious thing, which was not earlier. Second, I would like to, Anil Kapoor, I don't know if anyone over here, he is an Indian actor in India. So his case was his voice. He has a typical dialogue called Jhakas, the way he says in India. So he's a famous celebrity, Bollywood actor, Anil Kapoor. So what had happened, there are multiple people who were using his voice. People were using his voice, and then he instituted a case. Okay, under the celebrity or personality right, saying that his voice should not be misused without his permission. Now in this judgment, what is important is to note here is the remark which was given by the Indian courts that misuse, okay, of the celebrity right or the personality right by the use of AI also amounts to infringement. So these remarks were emphasized by the Indian court that even you are using AI to infringe the rights of third party, it also amounts to trademark infringement. So this was also major landmark recently given, I guess this year itself this judgment was delivered. So now they are addressing the upcoming issues which are there, that AI is very much a hot topic that we are dealing with. Similarly, there was a case of a copyright in India. Now this was a case of Anil Sahani, who was the inventor, also creator, the artist, and he was also a lawyer by a profession. So he had applied for a copyright for his drawing called Raghav. Okay, the Raghav was the AI, and he had co-authored that particular creative work. So this copyright was applied in US as well. So in US, this application was rejected on the grounds that there is not much human contribution to this work, and therefore it's not a valid for the application. And the application where the AI was a co-author was rejected in US. But in India, unfortunately, this application got accepted, and copyright was issued to him. But after the US decision, Indian Copyright Office decided to cancel his registration with the notice saying that it is on withdrawal. A withdrawal notice was sent to him. But then this decision is again challenged by the applicant, that how can, once the copyright is already issued, how can the registrar review his own orders? So, but that is still in limbo, it is yet to be decided. But India are dealing with the case where the AI and the ownership are an issue. So as of now in India, it is bound to change that when we say author, there has to be a natural person. Because all our IP acts, maybe patent, trademark, copyright, it says that there has to be a natural person. So as of now, we are following this precedent. But as I mentioned, that law is evolving in this space. So we might have a different scenario in near future, but this is at the present scenario in India. Another case which I would like to mention is a very interesting case. I don't know whether this brand is in Turkey or not. Parley. It's a biscuit brand in India, and Oreo, which is of Britannia. Now they have a very peculiar design on the biscuits. Now this is a first of a kind case which has been come to the Indian courts, which says about the design infringement. Now what is infringement in this case? Infringement is basically the surface, it is a cream biscuit. The surface of the biscuit has a unique design. So one party is claiming that we have a design registration for this particular artistic creation, and what the second party is doing is infringement. And this will be the very interesting scenario. The decision is yet to be given. But as we all know, when we say design, I hope the section is same in Turkey. The articles can be sold individually. If any article wants to qualify as for the design registration, it should be sold individually. So if there is a design on biscuits, biscuits are not sold, each biscuit is not sold individually. So this will be a one of its kind, that judgment will be, we are awaiting for that judgment. So there are different scenarios coming before the Indian Patent Office where the use of technology and are challenged in each and every cases, and we get new kind of judgment every time. Even the keywords cases of booking.com and it was Make My Trip. So use of trademarks as keywords on the search engine. So in India, the settled law is that it is not an infringement, right? So use of keywords when you are doing a search on a Google does not amount to infringement.
It's the other way around.
Yes, it amounts to infringement. Yes, sorry. So it amounts to infringement. So that's why the law is evolving in this space. Laws in India are trying to be at par with the global trends that are coming up. So this was on the judiciary side. On the statutory part, one point which I would like to mention is now India is adopting a different criminal set of laws. Earlier we were having Indian Penal Code. Now the new laws will be enforced. They are not yet in action as of now, but we are on the verge of application which are called BNS, that is Bharatiya Nyaya Sanhita. So that is which will be governing the criminal law. The reason for mentioning this because most of the IP offences have a criminal remedy in it. Okay, so most of the economic offences and cyber crimes, the accountability of these two offences will be included in the new criminal law that India will be adopting. They will be enforced soon. They are passed by the parliament, but they are not yet enforced as of now. So these are the major, I would say, the points which I wanted to mention. Secondly, about the well-known mark. Now I saw that the earlier speakers mentioned about the well-known marks that trademark officers don't have authority to recognize a mark as a well-known mark. But in India, we do have a procedure wherein certain forms, and there is a huge documentation in this case, and the government fees, if it is anticipate, then yes, mark can be recognized as a well-known mark. So this is a recent addition to the trademark laws. And also with regard to description, which earlier panelists mentioned about, that nowadays the applicant pick all the class, like subclasses also. So in India, basically the Indian Trademark Office is becoming very stringent nowadays. So they are actually asking for the specific description and the words from the niche classification. So any new words is they are reluctant to accept. So when we are submitting our application for the trademark filing, the description should be properly drafted, because that gives unwanted examination is there and that delays the process. So it is ideally recommended that it should be accurate and very specific to the business that you intend to do or presently doing. So these were the major points which I noted from the earlier speakers as well. So I guess any points you would like to add?
Yeah, I'll start from where I left. There have been, as I said, there have been significant changes, both to make the procedures easy and to bring in the speed and quality of the grant of patents and trademarks. That has been a focus of India for the last 10 years, and significant results have come from that. I would also like to say that there have been some procedural issues in Indian patent law which has been considered as the pain points by most of the global filers to attract more filing coming from the global players for patents. Particularly, the government has taken a proactive step this year itself, effective March 15. They amended the patent rules. Because the amendment in a patent law is a tedious legislative process. So instead of going through the parliamentary route, they rather prefer to take administrative route to amend those the rules. And some of the important features of this amended rules particularly are related to some of the unique requirements which were there in the Indian law. Like we have a provision called section 3A, section 8.1 and 8.2, which makes a burden on each patent applicant to file the details or submit the details of corresponding applications with the Indian Patent Office frequently. So if a patent filer has filed applications in, say, US, Europe, China, Japan, or maybe other countries, like any other country, they have to file the details of those applications with the patent office periodically, and within 6 months of a new filing coming, new filing is being done, they have to report it to the patent office, which was a very tedious requirement on the objective of that was that while Indian patent application is being examined, the patent examiner should know what is happening in the other corresponding application and can see the granted claims of those or the objections which have come to those corresponding applications. So the burden was on the applicant to provide the details. Under the amended rule, now the burden has gone into the patent office. So because most of these data is available online through eSpaceNet, and European Patent Office also maintains the family details of all the applications. So the new rules now passed on the burden on the examiner. While examining the Indian application, they have to go through the public database and check what's happening in the corresponding application. And only if they do not find any document, then only they can ask the applicant to submit that application. Insofar as providing the details of application, the rules now have made it only twice. The applicant has to give it, one at the time of filing the application and one after the issuance of the first examination report. That within 3 months they can file the details of the corresponding application. But the applicants are not required to submit any data in terms of the search or examination reports or granted claims to the Patent Office anymore. The second most concerned or debated topic was the working statement. Under the Indian patent law, there's once the patent is granted, the all patentee and licensees are required to file annually a working statement providing, making disclosure whether the Indian patent is worked in India or not, and if worked, then what is the volume of sales, and they have to disclose the revenue also generated by if it is by way of licensing, then they have to provide the details of the licensing revenue which has come in terms of royalty and or upfront license fees. This disclosure was again very non-business friendly, because the reason being that most of the companies, global players, would not like to disclose their revenues, which becomes a public data, or to tell about their licensing revenues. So the government has now, I will say it's not elimination of the requirement, but it has been significantly mitigated. Now, instead of filing annually, they have to file the working statement every third financial year, at the end of every third financial year, one. And significant part is that now they don't have to make any disclosure except to state whether the patent is being worked or not worked. If worked, then there's no other data which is required to be given. If not worked, then they can give the reason for not working. And also there's an option for them to, if the patent is open for commercialization, it's not worked and open for commercialization, they can provide the details or contact details of the person whom any interested or potential licensee can contact and can start the negotiation. The significance of this working of patent was also on the enforcement side, as well as on the mainly on the enforcement side, and also was one of the reasons for issuance of the compulsory license. So if a patentee gets a patent, let's say for a life-saving drug or an anti-cancer drug, but opts not to use that in India, right? Patent. So neither by importation nor by local manufacturing, the product is not available. Then he has to make the disclosure that it has not been worked. Based on that, any party who is interested can apply for a compulsory license. That can apply for compulsory license only after going to the patentee, approaching the patentee for a voluntary license, and if the patentee refuses to grant a voluntary license, then they can go to the government and get the license. But that was a provision which is there in the laws so far, but at a policy level, I will say the government has not, except for one case in 2008, that was an ex-Award case, and the government has not ever entertained any compulsory license applications by anyone. So that way it is almost like a redundant provision. That has been significantly now been mitigated by this amended rules. There have been some the provisions related to filing of divisional application has always been subject matter of debate in India, whether the divisional application can be filed voluntarily or not. Now that position has also been settled. Voluntary divisional applications can be filed, and it can claim any of these the feature or the inventions which are being disclosed in the priority in the first application. So the claims of the divisional do not have to come from the claims of the parent application anymore. It can come from the specification of the application. On the enforcement side, I'll just to add what Siddharth started about how the IP divisions have come. So significant change happened in 2015 when the Commercial Code Act was implemented in India, and the IP was made as a commercial dispute, which means that all the commercial courts which are designated as commercial courts could hear the IP matters at district level and also at the High Court level. But in 2022, two of the High